Welcome. Welcome to this year's Owen J. Roberts Memorial Lecture, which is, as I'm sure you all know, the oldest and most distinguished lecture here at the University of Pennsylvania Law School. Penn Law established the Roberts Lecture more than half a century ago to honor the memory of one of our most distinguished graduates. Owen J. Roberts' remarkable accomplishments epitomize the phenomenal difference lawyers can make in almost every aspect of our society. He began his career as a member of the Penn Law faculty and ended it here as dean. In between, he was one of the great practicing lawyers of his generation, a federal prosecutor during the Teapot Dome scandal, the Watergate scandal of his day, and an associate justice of the U.S. Supreme Court for 15 years during the era of the Great Depression and the Second World War. Roberts' career was extraordinary from the beginning to end. After all, it's not every Supreme Court justice who retires to become a law school dean. I wonder, of course, if any of the current justices are contemplating such a congenial career change in the near future. Throughout his career, Roberts engaged with the most important issues of the day. His famous switch-in-time vote upholding a state minimum wage law for women in West Coast Hotel Company versus Parrish marked a watershed in constitutional law, setting in motion judicial ratification of the New Deal's expansion of federal authority. Making that kind of difference in constitutional law is one reason it is so very fitting that we welcome Laurence Tribe to deliver tonight's lecture. In many ways, Professor Tribe requires no introduction, but let me do so anyway. To say that Professor Tribe has a level of public recognition and influence that is rare for a legal academic is an understatement. It's been aptly said that no lawyer or scholar who has not been a member of the U.S. Supreme Court has ever had a greater influence on the development of American constitutional law than Laurence Tribe. Kathleen Sullivan, herself a Roberts lecturer and we're privileged to have here today, perhaps best summed up his career when she wrote, "No one else has combined the roles of constitutional scholar, constitutional advocate, constitutional policy advisor, constitutional drafter, and constitutional commentator with the breadth, depth, and brilliance of Laurence Tribe." Like Owen J. Roberts, he exemplifies our law school's ideal of joining theory to practice and scholarship to social engagement. The Carl M. Loeb University Professor and Professor of Constitutional Law at Harvard, he has taught there since 1968. And I want to note he was voted the best professor by the graduating class of 2000 and holds the title of University Professor, Harvard's highest academic honor that is only enjoyed by a handful of faculty. Professor Tribe is best known within legal academia as the author of the landmark treatise, American Constitutional Law. It's impossible to overstate the influence of that work, which has been cited more often than any other contemporary legal text, including scores of citations by the U.S. Supreme Court. So special is its place in the canon of constitutional scholarship that when Professor Tribe decided in 2000 to suspend publication of future editions, a decision one law professor likened to Michael Jordan leaving basketball at the top of his game, it made headlines. Why would he turn his attention away from his landmark treatise? At the time, he said, that conflict over basic constitutional premises is today at a fever pitch, and that no treatise, in my sense of that term, can be true to this moment in our constitutional history. His sense of the moment led in 2008 to the publication of The Invisible Constitution, in which he attempted to shift the discussion, as he put it, from whether various constitutional claims are properly rooted within the constitutional written text to whether claims made in its name rightly describe the content, both written and unwritten, of our fundamental law. Whether you view that as a poke in the eye to textualism, a brilliant intellectual turn, or maybe both, it is a measure of Professor Tribe's broad intellectual ambitions. First and foremost, a constitutional expository Over the years, his interests have been covered to include civil rights and civil liberties, privacy law, sexuality in the law, reproductive rights, criminal law, procedure, cyber law and internet policy, government structure, human rights. The list goes simply on and on. In addition to American constitutional law and the Invisible Constitution, he has written over 100 books and articles, including the books on reading the Constitution with his former student Michael Dorf, and Abortion, the Class of Absolutes. Professor Tribe's political perspective is decidedly liberal, but not decidedly so. He has argued for some significant autonomy for states and localities as a matter of federalism, just as he has championed progressive constitutional thought with its protections of personal dignity and equality. As he has observed, there really is no unitary theory that can make sense of the whole Constitution. I think that both those liberals who read the Constitution as expressing some single vision of human rights and those conservatives who read it as expressing some single vision of structural checks and balances are making the same kinds of mistakes. Professor Tribe has wedded his scholarship to a remarkable constitutional law practice. He's argued before the Supreme Court at least 36 times on a wide range of issues, from privacy and employment rights of gay people, to the authority of city governments to reserve the benefits of their capital investments for local residents, to the power of the state to take property for public benefit, less tangible than physical use. He's extended free speech rights by gaining press access to criminal trials, and has sought to extend free speech rights to the allocation of federal family planning funds. He's argued against limits on the size of the scope of the punitive damages and helped to limit the effects of asbestos claim settlements on future claimants. His intellectual and political commitments follow a personal path. Professor Tribe was born in Shanghai to Russian immigrant parents who were part of a refugee community in China that had escaped the Russian Revolution and the Holocaust. During World War II, his father, who had become a U.S. citizen, was interned by the Japanese as an alien national, an injustice that he has said led to a lifelong commitment to justice and the rule of law. Professor Tribe entered Harvard in 1958 at the tender age of 16, graduating summa cum laude in mathematics before turning his attention to law when he graduated magna cum laude from the Harvard Law School. After graduation, he clerked for the California and U.S. Supreme Courts and began his remarkable academic career. I should note that his influence is truly global. As a constitutional consultant, he has lent his knowledge to the drafting of several national constitutions. He helped the Marshall Islands draft a new constitution in the late 70s, served on the U.S. European Committee on the revision of the Czechoslovakian Constitution in the early 1990s, and acted as a constitutional advisor to the Chief Justice in Russia. As Judge Stephen Reinhart put it, Larry has been a major exporter of the very best commodity that the United States has to offer, its constitutional values. Over the years, some of the most distinguished members of the judiciary and academia have served as Roberts Lecturer. Justice Felix Frankfurter, Judge Henry Friendly, Archibald Cox, John Rawls, happy to say with us today Kathleen Sullivan, as well as John Gibbons, to name just a few. Tonight, I trust you all agree that we add a new star to that constellation. The title of Professor Tribe's talk tonight testifies to the great imaginative leaps that have characterized his scholarship, the puzzling place of coercion in constitutional analysis, from the Lindbergh kidnapping to Obamacare to fighting HIV/AIDS without protesting prostitution. Without further ado, therefore, let me please welcome the 2013 Roberts Lecturer, Laurence Tribe.
Thank you so much, Dean Fitz. That introduction is a pretty hard act to follow. I'm wondering, who is that guy? As if it weren't hard enough to be following in the footsteps of some wonderful former students of mine like Kathleen Sullivan, Harold Coe, Cass Sunstein. your own former wonderful dean, the late Lou Pollack, and then various other lecturers, Amartya Sen, John Rawls, Ronnie Dworkin, Scalia. It's humbling. And it's also humbling to be delivering a lecture in honor of Justice Owen Roberts, who, as the dean told you, cast a crucial vote in 1937 in West Coast Hotel versus Parrish, best remembered as the switch in time that saved the nine, even if the intellectual substance of his reversal of position is sometimes forgotten. In voting to uphold Washington State's minimum wage law after having voted to strike down an indistinguishable law enacted by the state of New York, Justice Roberts famously broke with the block of 4 laissez-faire justices who had quite consistently voted to strike down economic regulation designed to protect workers and consumers from bargains that the legislative branch deemed unfairly exploitative and socially harmful. And in the same year, he joined with Chief Justice Hughes and Justices Cardozo, Brandeis, and Stone in NLRB versus Jones and Laughlin, upholding federal labor legislation that he and the other 4 conservatives would, just a year earlier, have unhesitatingly struck down along with much of the rest of the New Deal in an intrusion upon the reserved rights of the states. Justice Roberts' break with the coalition that had extended the so-called Lochner era into the early 1930s is quite often caricatured as a purely strategic response to external political pressures from the Roosevelt administration. But historians long ago showed that Roberts' seemingly sudden reversal is better understood as the product of a gradual evolution in his legal philosophy, tracking fundamental shifts in both academic commentary and popular sentiment, and reflecting sensitivity to changing economic realities and evolving concerns with distributive justice. Underlying the political drama of Roberts' switch in time was the growing conviction that much of what prior cases had protected as freedom to contract was really disguised coercion. Not all of the doctrine that the Supreme Court had pronounced in the Constitution's name from the turn of the century to the 1937 decisions in cases like West Coast Hotel v. Parrish and NLRB v. Jones and Laughlin was destined for the dustbin of history. Even Lochner itself, the 1905 decision invalidating a state maximum hours law, is enjoying something of a scholarly revival. And with a frequency that some find hopeful while others find alarming, the Supreme Court or individual justices are issuing opinions that others understandably describe as sounding in a kind of Lochner-esque register, opinions like the majority in the Vermont drug prescription case, IMS versus Sorrell, the Scalia plurality in the Florida beach restoration case, the dissent of Chief Justice Roberts joined by Justices Scalia and Alito in a screwy little Indianapolis sewer improvements tax case decided last year. Those are straws in the wind, but that revival hasn't become mainstream, at least not yet. And 2 groups of Lochner-era decisions never left the mainstream. There's one key strand of decisions beginning in the 1920s with Meyer versus Nebraska and Pierce versus Society of Sisters, both involving not just liberty of contract, but parental autonomy. They survive today in decisions protecting reproductive and sexual liberty, from Griswold v. Connecticut to Roe v. Wade to Lawrence v. Texas, and most recently, Windsor versus United States, striking down the centerpiece of the so-called Defense of Marriage Act. Now, the liberal justices who embrace these decisions while resisting the revival of Lochner-style economic due process are walking a shaky tightrope. As Justice Scalia has put it, in the real world, a stark dichotomy between economic freedoms and civil rights does not exist. For he who controls my economic destiny controls much more of my life as well. Another key strand of decisions beginning in the 1920s, with cases striking down state efforts to condition the privilege of doing in-state business upon sacrifice of the right to resort to federal courts, has survived in the second half of the 20th century and beyond in the line of decisions dealing with so-called unconstitutional conditions. That line of cases, which is the focus of this lecture, is exemplified by Spicer versus Randall, in which the Supreme Court in 1958 invalidated a state law conditioning special property tax breaks for veterans upon their signing a loyalty oath, and culminated this June with the decision in a case called Agency for International Development versus Alliance for an Open Society, striking down a 2003 act of Congress that appropriated funds to support the efforts of non-governmental organizations combating HIV/AIDS throughout the world, but denying such federal funds to any organization that, quote, does not have a policy explicitly opposing prostitution. So you could get money to fight HIV/AIDS, but only if you had such an explicit policy. Writing for a six-justice majority in that case, Chief Justice John Roberts conceded that the imposition of Congress's anti-prostitution condition was not coercive, in the sense of what he called an offer that cannot be refused. He was clearly channeling not just The Godfather, but also the late Robert Nozick's wonderful definition of a threat as an offer that you would rather not receive. Justice Scalia argued in dissent that these non-governmental organizations had no right or entitlement to federal financial assistance in their charitable efforts to fight dread diseases, and so they were perfectly free to just say no to the federal offer if the strings that Congress attached to that offer were not to their liking. To that, Chief Justice Roberts essentially replied, true, but so what? What makes a condition unconstitutional, Roberts reasoned for the court's majority, need not be its coercive character. It could be something else altogether. But what else? That's the question, and it's a question with which many have grappled, but none, certainly including me, has entirely answered. The unconstitutional conditions puzzle has generated a veritable cottage industry of academic commentary, stretching from Robert Hale's classic 1935 essay in the Columbia Law Review to Kathleen Sullivan's magisterial 1989 analysis in the Harvard Law Review, and including a student note in none other than your own Law Review in 1968. It's a puzzle that I actually encountered myself for the first time when I was just a kid, clerking at the Supreme Court in 1968 for Justice Potter Stewart. Decades earlier, and 2 years after Herbert Hoover had appointed Owen Roberts to the Supreme Court in 1930, the 20-month-old son of Anne Morrow Lindbergh and Time magazine's first ever Man of the Year, Charles A. Lindbergh, the great aviation hero, had disappeared from the Lindbergh family home near Hopewell, New Jersey. The baby's body was found 2 months later, buried nearby, his skull brutally smashed. 2 years later, Bruno Richard Hauptmann was charged with the gruesome killing. After a trial in early 1935, he was convicted of first-degree murder and sentenced to die. Put to death in New Jersey's electric chair in April 1936, Hauptmann protested his innocence until the very end. The media interest in that case rivaled the attention lavished on O.J. Simpson or on the death of Princess Diana in that infamous paparazzi chase in the tunnels of Paris. H.L. Mencken called the Lindbergh kidnapping and trial the biggest story since the resurrection. In 1932, not long after the baby's disappearance and discovery in a shallow grave, Congress enacted the aptly named Lindbergh Law, making kidnapping a victim across state lines a federal crime, an exercise of the commerce power to deal with a non-economic problem in a manner that was of dubious constitutionality under the law as it then stood, and might honestly be thought to raise serious constitutional issues even today, although its validity was taken for granted between 1937 and the current decade, certainly at the time I was working as a law clerk in '68. Nor was there any doubt then about the constitutionality of the death penalty that Congress appended to the Lindbergh Law in 1934, just as there would be no doubt about it in today's Supreme Court. But the federal law did pose a problem in 1968 when I first had to grapple with it as a recent law school graduate working in Justice Stewart's chambers. A kidnapping defendant named Charles Jackson, nicknamed Batman, challenged his indictment under the Lindbergh Law on the ground that the 1934 amendment to that law permitted imposition of the death penalty only upon a jury's recommendation. Batman argued that this amendment impaired his constitutional right to a jury trial under the Sixth Amendment by making the risk of death the price of asserting that right. Now, given the way the death penalty had been structured in 1934, a defendant who abandoned the right to contest his guilt before a jury was assured that he couldn't be executed. The government tried to solve the resulting problem by proposing a construction of the statute whereby federal judges could reject a jury recommendation of death or could impose a death sentence even without a jury recommendation. I recall really well how much the court, and Justice Stewart in particular, struggled with that ingenious proposal. In the end, the justice wrote, and a majority of the court agreed, that it would violate the separation of powers for the court to create from whole cloth a complex and completely novel procedure and to thrust it upon unwilling defendants for the sole purpose of rescuing a statute from a charge of unconstitutionality. The next thing the government argued was that the statute's aim was to ameliorate the severity of punishment, not to deter or penalize the exercise of the right to jury trial. The court made swift work of that argument, saying that whatever its purpose or motive, the fact that the statute operated to penalize the exercise of the right to jury trial without adequate justification was enough to condemn it, provided that alternative ways of achieving the government's ends could be found, essentially subjecting the statute to an early version of what we now think of as strict scrutiny. More difficult was the government's argument that federal trial judges may be relied on to reject coerced pleas of guilty and involuntary waivers of jury trial. The idea being, well, if the guy pleaded guilty in order to stay out of the death chamber, it was not a voluntary plea. But given the long line of precedents, including Spicer v. Randall, that had been decided a decade earlier, where conditions had been struck down as unconstitutional even when there was no doubt that the recipient of the conditioned benefit remained entirely free to turn it down. I mean, these veterans could have just turned down the property tax exemption. They weren't coerced into accepting it. The court responded in light of those cases, the evil in the federal statute is not that it necessarily coerces guilty pleas and jury waivers, but simply that it needlessly encourages them. And again, quoting from the court, a procedure need not be inherently coercive in order that it be held to impose an impermissible burden on the assertion of a constitutional right. Accordingly, the court made plain that its holding in Jackson did not jeopardize the many guilty pleas that had been entered in preceding years to charges under the Lindbergh Law. A conclusion the court invoked just a couple of years later to uphold a plea of guilty under the Lindbergh Law in a case called United States versus Brady. So if you plead guilty to avoid death, you're out of luck. It's a voluntary plea as long as you're adequately counseled. But if you resist and do not plead guilty, you can succeed in invalidating the law that says you will be jeopardized only if you waive your rights. Another novel solution the government proposed was for the court simply to direct all federal trial courts under its supervisory powers to reject any defendant's attempt to plead guilty or waive jury trial. In other words, any such attempt, because it's being influenced by an unconstitutional condition, should not be accepted. The court, after all, had previously held in a case called Singer versus United States that the right to jury trial is asymmetrical, that it doesn't imply a mirror image right to insist on a trial before a judge rather than a jury. True enough, the Jackson court reasoned, but that hardly implies that all defendants can be required to submit to a full-dress jury trial as a matter of course. The court noted the cruel impact of such a requirement on defendants who would much prefer not to contest their guilt. And it also noted that our whole criminal justice system would collapse if you automatically rejected all guilty pleas because the person was getting a better deal for pleading guilty. Why else do people plead guilty? What the court said, and this was a kind of early version of what people call the clear statement principle, was that it would require an unambiguous expression on the part of Congress to withhold the authority on the part of judges to accept pleas of guilty and waivers of jury trial. Two justices, black and white, appropriately, dissented, essentially arguing that the judicial power to reject coerced guilty pleas solved the whole problem. But to do that, they had to ignore the whole line of precedent, making clear that coercion is not the only problem that the unconstitutional conditions doctrine is designed to solve. I started worrying as I was preparing this lecture that maybe I had made the same mistake when I was writing that treatise that I discontinued, American Constitutional Law. So I looked at it, and thank God, to my relief, I found that I had described the doctrine as addressed, the doctrine of unconstitutional conditions, as addressed to those government conditions that link receipt of benefits to which one has no ex ante entitlement to the unwarranted forfeiture of an independent constitutional right, however knowing and voluntary. It can be perfectly voluntary and yet still be an unconstitutional condition. It really should be plain, I think, that notions of coercion do not play an indispensable role in the unconstitutional conditions doctrine. Now, confusion arises because of the constitutional significance of coercion in those circumstances where a condition does operate literally like a gun to the head to coerce a person or a state to sacrifice what is independently secured as that person's federal or state's federal constitutional right, and does it without sufficient justification. In those circumstances, it follows, without any fancy doctrinal footwork about unconstitutional conditions, that the condition amounts to a straightforward violation of that independently secured right. In a book that a recent student of mine, Joshua Matz, and I are currently completing, desperately working to complete on time for publication next June, just before Joshua starts his clerkship with Justice Kennedy. It wouldn't do for the book to come out while he's in the court. Everybody would then say we were, getting inside dope. A book called Uncertain Justice, The Roberts Court and the Constitution. In that book, we argue that this simple principle, contrary to conventional wisdom, fully accounts both for the vote of Chief Justice Roberts to strike down the individual purchase mandate of Obamacare under the Commerce Clause, and for his vote to uphold that same mandate under the taxing power, votes that some people thought were irreconcilable, but votes that I think turn out to be completely consistent. We also argue that the same anti-coercion principle also accounts fully for the court's remarkably lopsided 7-2 vote to strike down the financial penalty that Congress had sought to impose on those states that declined Congress's offer of a big bucket of money to expand Medicaid, including the quite surprising votes of Justices Breyer and Kagan to join the conservatives in that unanticipated holding, a holding that now has led 26 states to turn down Congress's expanded Medicaid offer, arguably jeopardizing the viability of Obamacare in its entirety. But that's another story that our book explores and that I'll have to leave to one side this afternoon. So coercion is often a sufficient factor to doom a government action without recourse to the unconstitutional conditions principle. But it's not a necessary factor in the effort to invalidate a government action when the unconstitutional conditions principle is properly invoked. A good example of that, of course, was Agency for International Development versus Alliance for Open Society, where it was absolutely clear, and the Chief Justice, in writing for the majority, admitted it, that these organizations were doing perfectly well without the added money that the federal government was adding. So they weren't forced to take the money in the way that states, which had been told you'll lose all of your Medicaid money if you don't take the federal government supplement, were forced. They weren't forced. And so the dissenting position by Scalia and Thomas that since they weren't forced, there was no problem, really would have been decisive if coercion had been indispensable. And yet, looking at cases like United States v. Jackson and Spicer v. Randall, the majority, to some people's surprise, because after all, Roberts is no great liberal. I mean, I know I taught the guy, and you all know, you've read his opinions. He nonetheless said it violates the First Amendment for the government to make this offer. The only ones who were really out of step in that case were Thomas and Scalia. Now, Justice Kagan, having participated in the early stages of that HIV/AIDS case while she was Solicitor General, recused herself. So I think she can be forgiven for having said, dissenting in another case decided by the court 5 days later, a case called Kuntz versus St. John's River Water Management District, that, and I now quote her, "The entire unconstitutional conditions doctrine rests on the fear that the government may use its control over benefits to coerce a person into giving up a constitutional right." Now, I'm sure that Justice Kagan didn't mean that. She is a brilliant student of constitutional law and a brilliant justice. I just think that was a slip. In addition to disavowing the centrality of coercion, the court's recent decision in Agency for International Development repudiated another idea that has sometimes plagued challenges to conditional spending programs. It's the idea that what might otherwise be doomed as a government decision to penalize the exercise of a right can automatically be saved by recharacterizing it as a decision just to avoid expending public resources to subsidize or support a particular course of action. So, for example, the government can selectively fund public schools without funding parochial schools. It can selectively fund childbirth without funding abortion. But it's often argued in response to that when the federal government gives an organization money, since a dollar is always a dollar, it's just fungible, it may simply release money to be used for the forbidden purpose. That is, when money is given to these organizations to promote or, if Congress could prohibit, as it can, federal funds from being used to promote or advocate legalizing prostitution, why can't it simply say that if you're going to get federal money, since that money might end up on the wrong side of the prostitution ledger, by advocating something we want you to oppose, we can say that unless you take a pledge to oppose prostitution, you can't get any of our money. Chief Justice Roberts responded that a recipient could not avow the belief dictated by the government when spending federal funds, and then turn around and assert a contrary belief or claim neutrality when participating in activities on its own time and dime, because that would surely conflict with the recipient's pledge of allegiance to the government's goal of combating prostitution. And he said it wasn't enough to note, as the government did in this case, that the federal pledge requirement prevented the grant of federal funds from freeing a recipient's private funds to be used to promote prostitution or sex trafficking. The court's rejoinder was that the fungibility of money argument assumes that federal funding will simply supplant private funding rather than pay for new programs or expand existing ones. Now, the government said, look, you're sandbagging us. We made that very same argument, and you bought it for a majority of the court just 3 years ago in a case called Holder versus Humanitarian Law Project. In that case, the court had upheld a ban on providing material support to terrorist organizations, even when the support was directed simply to training those organizations to engage in entirely peaceful, non-terrorist activities. The court in that case had insisted that the record indicated that support for those organizations' nonviolent operations might be funneled to support their violent activities. Now, the court has made some effort to reconcile those two cases in terms of what the record in each case showed, but the effort wasn't really convincing. Demonstrating that would again take us a little bit far afield. But what matters for my purposes this afternoon is that the court in Agency for International Development finally began looking critically this year at the much too easily deployed argument that because money is fungible, government's authority to avoid subsidizing an activity encompasses authority to withhold funds or other benefits from anyone who engages in it. I mean, just think about what it would mean if the law were otherwise. The government doesn't have to subsidize abortions, but does that mean it can withhold food stamps or housing allowances from women who have abortions? Not even members of the court who are opposed to Roe v. Wade would go that far. But how to draw those lines is something that I have to leave aside. It's a difficult issue. What I will attempt to do in this lecture is to look at the flip side of the mistaken argument made by Justices Black and White in their dissent in Jackson, and by Justices Scalia and Thomas in their dissent in Agency for International Development, and made, I think, not after careful consideration by Justice Kagan in her dissent in the Kuntz case, namely the argument that coercion is the source of all evil in these unconstitutional conditions cases. The flip side is the counterintuitive argument that sometimes it is precisely the absence of coercion that is the source of a distinct and equally important constitutional evil. My favorite example is one that I've sometimes used in my constitutional law courses. It arises from New Hampshire's requirement, imposed without any apparent recognition of the irony involved, that every driver in the state must agree to carry a license plate bearing the inscription, "Live free or die." If you don't carry the "Live free or die" license plate, you live in jail. In an opinion by Chief Justice Berger, the Supreme Court held that New Hampshire could not sentence this guy named George Maynard to a 2-week jail term for cutting away part of his car's license plate for reasons of conscience. He removed the words "or die," leaving visible only the words "live free." The court invoked free speech principles in an opinion universally celebrated by civil libertarians. It relied on Justice Jackson's stirring 1943 vindication in West Virginia Board of Education versus Barnett of the freedom of students in a 4-room schoolhouse in the West Virginia countryside who had refused to join the rest of their class in reciting the Pledge of Allegiance, despite the fact that their refusal had cost them the privilege of attending the state's tuition-free public schools until they would relent. The court in West Virginia Board v. Barnett said you can't suspend them, you can't kick them out for refusing to say the pledge. And the court had lots of eloquent language, as Justice Jackson was wont to do, about how if there's any fixed star in our constitutional constellation is that the government can't make anybody recite an oath of allegiance to any particular political view or any particular religion. The court said in the Berger opinion in Woolley that making little kids mouth a pledge they don't believe is a lot more invasive than making some guy put a license plate on his car that he doesn't find congenial, but the principle is exactly the same. But let's take a look more closely at these cases. Consider the aftermath for Marie and Gaithy Barnett and for George Maynard of the court's decisions that were applauded by civil libertarians. Although it overturned the punishment of the Barnett girls for refusing to recite the pledge and set aside George Maynard's punishment for refusing to turn his car into a moving government billboard, it did not rule that the state of New Hampshire had to stop printing its "Live Free or Die" slogan with tax funds and distributing the resulting license plates to those licensed to drive in the state. Nor did it rule that the routine recitation of the Pledge of Allegiance at the start of every public school day must end, something the court has ruled for the past half-century with respect to school prayer, and something the court has been asked to rule just a couple weeks ago with respect to official prayer at every town board meeting in a case called Town of Greece versus Galloway. Instead, the court held only that the government has to give dissenters like the Barnett family and Mr. Maynard a chance to opt out of those activities without paying any government-imposed penalty, like losing your driver's license or going to jail or being suspended from school. But by the very act of visibly opting out, didn't George Maynard and the Barnett girls, in fact, pay a penalty that they had been able to avoid before the court had done them the favor of making the affirmative recitation of the pledge or carrying of the state's slogan optional? That's a point that struck me every time I taught Barnett and Woolley, particularly since I hadn't seen any discussion of the cases. Note the irony. I wrote in an article in 2001, by holding that individuals have a right to refuse a state slogan on their plates while letting the state keep distributing plates bearing the slogan, the court was forcing those who are most offended by the slogan to come out of the closet. No longer able to just blend in as law-abiding citizens whose views nobody could guess from their license plates, now those keeping the "Live Free or Die" slogan would be marked as having no objection to the sentiment that it expressed, while those replacing it would be marked as having affirmatively rejected it, and likewise for the kids in West Virginia. Not every dissenter wants to be a zealot or a poster child for a cause, and the privacy, as well as the free intellect and spirit of those dissenters, deserves protection. Justice Kagan made an identical point in the oral argument a couple weeks ago in the Town of Greece official prayer case. She said, I'm paraphrasing, inviting those people who are offended by the prayer that's recited at the start of the town meeting to slink out of the meeting hall, which is what basically the government said they don't have to stay, amounts to conditioning their full membership in the community on identifying themselves as religious dissenters. So the problem, as I kept telling my students ever since the late 1980s, including a student named Elena Kagan, but also one named Barack Obama, whose administration is defending the Town of Greece in that case, was that the right to opt out of mandatory oaths like the Pledge of Allegiance or the town prayer ironically compels dissenters to choose between coming out as dissenters or lying about their beliefs. Likewise, the offer of a fully voluntary government bribe conditioned on the willingness to become a mouthpiece for the government's ideology, with which one might disagree, effectively smokes out private views by forcing potential recipients to make a public decision, take the cash and be understood to have put a price on one's convictions or reject it. The HIV/AIDS anti-prostitution pledge provides a perfect example. Once Congress made the pledge a condition of accepting funding without which the recipient could have continued its mission but on a lower budget, those who accepted the funds but opposed the pledge had just two choices: lie and express the government's position as your own, or attempt to maneuver through various technical regulations to find a way to express the convoluted message that you took the pledge, but only for the money, not because you believed it, which, as the Chief Justice noted, would be seen as hypocritical by many onlookers. Or if instead you reject the money on the basis of opposition to the pledge, you'd be under pressure to explain to the people that you keep going to for funding, both private and public, why you had rendered yourself so needy, inevitably conveying the impression that your opposition to the pledge was somewhere between impassioned and fanatical. In short, the government's conditional funding offer forced most recipients to choose among being liars, hypocrites, or zealots. Now, impressively, the Chief Justice, in analogizing these dissenting public health organizations to the vulnerable school children of an earlier era, evinced genuine sympathy for the no-win predicament, the catch-22 predicament that Congress had forced on these organizations, precisely because of the non-coercive character of the choice that it had put to them. In doing so, he demonstrated why government-sponsored bribes have the troubling potential to upset not just preferences, but preferences grounded in underlying constitutional rights for keeping your private views to yourself. was a point that I had stressed in the way that I taught Barnett and Woolley to the class in which Chief Justice Roberts had also studied con law with me. I have all these amazing students, Roberts, Kagan, Sullivan, very lucky. The Chief Justice didn't, I think, seem quite cognizant of the extent of his triumph. He said, "We cannot improve upon what Justice Jackson wrote for the court 70 years ago in Barnett." But he could, and he did. That is, his decision was more sensitive to the dilemma that is created by the non-coercive character of the opt-out option than Justice Jackson's decision had been in 1943. Unfortunately, he hadn't quite seen the same point when it all but surfaced a few years before his court in Rumsfeld versus Fair, one of the first cases in which John Roberts wrote the majority opinion since being sworn in the previous September. I say all but surfaced because I admit I hadn't seen it either. I had written an amicus brief on behalf of a whole bunch of professors. We tried the best we could to make it look like what Congress did when it told law schools all over the country that unless they gave access to military recruiters to their best facilities, despite their opposition to Don't Ask, Don't Tell, not only they, but the med school, the School of Public Health, the whole university would lose all its federal funding. We tried very hard to argue that was unconstitutional, and it was kind of an embarrassment when Roberts wrote a 9-zip opinion saying we were out to lunch. There was a faction of law schools called FAIR, the Foundation for Academic and Institutional Rights, that had sued the Defense Department challenging the constitutionality of this federal law, which required law schools to give military recruiters the same access to their campuses that they provided to other employers, even though the law schools were conscientiously opposed and wanted their students to know they were opposed to the Don't Ask, Don't Tell policy. The federal law was designed to bust a protest that these law schools had been carrying out since the late 70s, a protest against Don't Ask, Don't Tell. Now, the Solomon Amendment that was passed by Congress did not take the form of a direct mandate, a mandate with which all schools could readily have complied without revealing their views. That is, Congress could have said, as part of our power to raise and support the military, we require every university in the nation to allow military recruiters on their campus, regardless of what they think of the war in Iraq or the war in Afghanistan or the Don't Ask, Don't Tell policy or of the harassment of women in the military. But instead, it created this double whammy. It said, you don't have to do it. All you have to do is turn down all the money, and then you'll be fine. In a brisk opinion written by the Chief Justice, the court said, there's no coercion here, and therefore there's no problem. This is something you see that 7 years later, this same Chief Justice would come to recognize was not true, that the absence of coercion can be the problem. In fact, the schools that opened up their prime recruitment facilities under supposed protest, seeking to convey the message that they didn't agree with Don't Ask, Don't Tell, were confronted with the awkward question, so you oppose the government's anti-gay message, but not so much? That it's not quite enough to make your university sacrifice more than X federal dollars for sticking up to your supposed principles? Touché. I mean, I remember when Elena Kagan, who was then our dean, faced this terrible problem. So she goes to West Point. She's making a speech about how she and her faculty strongly oppose Don't Ask, Don't Tell. How much do you oppose it? Not quite enough, it seemed, to actually live your principles. So Joshua Matz and I argue in our forthcoming book that the Constitution should not easily countenance such suffocation of idealism, especially idealism directed in protest against the government and its policies. It shouldn't put people in the position of having to essentially state what the price point of their principles is. In making the argument that he had made in Rumsfeld versus Fair, Roberts and 8 of his colleagues overlooked the way in which it was precisely the absence of force, what I've been calling coercion, that made all of those laws constitutionally problematic. Problematic in the way that they smoked out beliefs that all of us should have a right to keep to ourselves. Where any such right comes from is the subject of another chapter of our book on informational privacy. So the upshot is that this is a minefield of ironies. From the irony of New Hampshire's live free or die mandate, to the irony of the Supreme Court's confusion in cases about conditioned benefits generally. While many of the justices ask whether a condition is the equivalent of a gun to the head, and if it is, then you don't have to think about it in terms of a condition. It's like your money or your life. That's not sort of a bargain. That's an assault. But they sometimes fail to realize that in some contexts, the visible gun to the head is the solution rather than the problem. Just visualize a prisoner of war confessing his treachery on a live video feed at the inducement of his captors. What he most fervently hopes is that the gun to his head, held there behind the curtain to increase the seeming sincerity of his condemnation of his own country, will be exposed for all to see, so that no one can mistake what he says for the views that he truly holds. When the government bribes individuals or institutions to abandon their principles and their rights in return for visible, tangible rewards, it puts them in the terrible position of making their personal and private priorities and principles entirely transparent to the world, a position that results precisely not from coercion, but from its all too conspicuous absence. The rights protected by the First Amendment and by the privacy principles that are presupposed and implied by the First, Fourth, and Fifth Amendments taken together encompass both the right not to express views that are not your own, not to be made the mouthpiece, the megaphone, the billboard for an ideology that you don't hold, but also the right to keep to yourself your private views. Now, you don't necessarily have a right to silence. I mean, if the government gives you appropriate immunity, it can make you testify. You don't have a right to silence. As I said earlier, not all rights are symmetrical. The right to jury trial doesn't imply a mirror image right to avoid a jury of your peers. So it's not that you have a right to keep your, to button your lip. The government can sometimes make you testify. You saw a crime, you can be held in contempt for not saying something about it. But what it cannot do is penalize you for refusing to express a view that you don't hold, or smoke out the views that you do hold by putting you in this double bind in which you can opt out, but only by effectively slinking out of the room and subjecting yourself to peer pressure and bullying. Putting constitutional rights on the auction block and treating them as just so many commodities, basically for sale to the highest bidder, can have a corrosive effect on the whole system of rights on which our constitutional order rests. It can ensure that rights become ours only by virtue of what we are able and willing to sacrifice for them, and not by virtue of the equal human beings that all of us are. It's not just votes that we should resist putting up for sale, but rights of many varieties. And it's not just in the complex world of campaign finance that a deep form of constitutional corruption can lurk behind the curtain of a world gone mad with money and with the dismal logic of transactions. Thank you very much. Thanks. Thank you.
I think I can say, and speaking for everyone in the room, that was a magnificent Roberts lecture. It deals with probably one of, if not the most knotty, complex issue in constitutional law, the question of coercion in unconstitutional conditions, and it's literally a minefield, and you tiptoed through it all with.
Well, I didn't blow up quite, but the problem remains to be solved. And if anyone is ever to solve it, it's Kathleen, who wrote the greatest article about it back in '89.
I would like to open it up for questions in the audience from all topics. I must say, it's quite a recommendation for the book that's coming out in a few weeks. Yes, sir.
Thank you for that. In the case of Greece versus Galloway, there seems to be something else as well. For instance, people who... Oh, sorry. Thanks. In Greece versus Galloway, one of the things that troubles me about that is that there are people who are present at these meetings who will be covered by your, being smoked out by their behaviour. But what about the people who object but aren't present at those meetings, who might not
I mean,
want...
people who, for example, simply don't show up because they would be upset by having to be outed. That is,
Right,
people think
right.
maybe you're staying home because you're watching the World Series, or maybe you're staying home because you're babysitting, and that way they can perhaps hide, and they are not put to the problem. But they have to sacrifice another right, and that is the right of public participation in self-government. I mean, it's a very deeply knotty problem. I mean, some of the justices seem tempted to say, we can't figure this one out, so let's just do what we did in Marsh v. Chambers in 1983, 30 years ago, where we said it doesn't necessarily fit our jurisprudence, but hey, from the very first Congress, there was practice of chaplains saying prayers. It didn't lead to a theocratic state. If the camel's nose got under the tent, where's the rest of the camel? And so one tempting thing is to say, we've done it that way for a while. But Justice Kennedy in the oral argument said, yeah, so that's basically your argument, right?
Right.
We've done it, so it's okay. Is that really what you believe, that when we violate the Constitution for a long enough time, it gets a kind of right of prescription, a sort of a prescriptive easement by adverse possession against the Constitution? He didn't quite go that far, but he certainly showed how troubled he was, both by the historical argument and by its absence. And sometimes when you can't find an analytic solution, you sort of punt and say, well, we'll create this little exception. But then you wonder, where does the exception stop? I mean, it's one thing to say that a chaplain will intone some anodyne prayer at the beginning of a legislative assembly. What God would listen to lawmakers anyway? But these are public citizens taking part in the governance of their community, sort of like kids taking part in a kind of preliminary embryonic form of self-government in public education. It's
Right.
very hard. But certainly one of the things in this case that's dramatic is that virtually all of the prayers were Christian prayers. And some of the justices said, do you think, I mean, it's true we begin our proceedings here with God save the United States and this honorable court, but if we began by asking everyone in the audience to sit there quietly while we intone the name of Jesus Christ, the Son of God, would that be okay? And the United States, which was appearing in support of the town of Galloway, said, oh no, that wouldn't be okay. So what's the difference? It's a hard one.
Thank you.
Oh, I got to, oh, you're here, go ahead. Do I understand you to be saying that the government cannot force a private party to speak for it? I'm thinking of the funding of family care, but not abortion, not doctors not able to tell people about abortions. The case that was distinguished in the Valquez legal services case.
Well, that case brings back painful memories. I argued and lost it 5-4. It's the case of Rust
I guess you've answered the question.
It's Rust versus Sullivan. And it was a very tough case. When I agreed to argue it, I knew it would be tough, but Brennan was still on the court. And then Brennan left and was replaced by Souter, and I'm absolutely convinced that 5 years later, when he found his sea legs, Souter, too, would have voted that it was impermissible as a condition of giving government money to family planning clinics, essentially to force them to lie to their patients. You see, it wasn't just a case of saying we're going to fund one set of activities over here, namely healthy babies. You want an abortion, that's something else. But the point is that the abortion clinic was across the street, and these poor young girls who came in the Bronx and elsewhere to the family planning clinic had every reason to think that the guys in white coats were not mini representatives of the government. They had a stethoscope. They didn't have some badge and a gun. And so these girls, when these guys couldn't tell them, they couldn't even mention that if, however, you think that all of my options about bringing up the baby and putting the baby up to adoption don't work, there's a place across the street that can give you wide-ranging advice. They weren't allowed to mention that. And so effectively, they were entrapping people. And that was an argument that I don't think I made well enough. I think in retrospect, I might have done better, but I think that Souter, just having joined the court, and I've had some conversations with him since, he hasn't ever said exactly, I think I was wrong. Sometimes justices do. When I lost Bowers v. Hardwick in 1986, the case that, thank God, was overruled in Lawrence v. Texas in 2003, Powell, the decisive fifth vote in Bowers after he left the court, said, you know, when he was talking to a group of students at NYU, he said, I think that I made one mistake in my years on the court. It was my vote in Bowers v. Hardwick. So I wrote him a nice little note saying, better late than never. He wrote back saying, showing that he didn't quite get it even then, yeah, I was wrong, but it didn't matter because people don't really prosecute others for this. But of course, what he didn't recognize was that it was a denial of equal dignity for people who are accused of, quote, sodomy, unquote, to say that the kind of intimate sex activity they might engage in makes them criminals, because that subjected them to all kinds of other discrimination. People said, oh, you're a criminal, therefore you can't adopt. Therefore, it's okay for us to discriminate against you in employment. And that's what Kennedy, writing for the majority, recognized so profoundly in Lawrence v. Texas. This wasn't just about the privacy of the bedroom, but it was about the equal dignity of a subpart of the population. Notice how I avoided saying too much about Russ v. Sullivan?
Yeah, I've wanted to ask this for a long time. It pertains to how terrorism, which is illegal, terrorism recently, the definition was just changed from terrorism to enhanced interrogation when you're questioning suspects in certain cases and methods. But what does the ordinary citizen do to combat the problem that I've seen is that we keep thinking about rule of law. And the trouble I have with that is those that are all powerful in military, in power in forces and manipulation, what is it to prevent those that are in power from just maneuvering the definitions and what is the law to suit their needs? How can the ordinary citizen combat that?
I'm not sure what the precise question is. I mean, I share your concerns about what the prior administration called enhanced interrogation, but what was really what was really torture. I'm also worried about some things this administration is doing in terms of assassination without trial through drone strikes. It's not much the ordinary citizen can do. The Supreme Court is not going to litigate on behalf of a group of Pakistani civilians. It's going to either invoke the lack of standing of people in the United States who seek to complain, or the political question doctrine. Those are deep questions. There's a wonderful book by my colleague Charles Freed, who people tend to think of as a conservative, but who with his son wrote a book about the sort of the intrinsic wrong of torture. And there are people who have a theory that torture is wrong in a way that even killing, after all, we kill people on a battlefield, may not be wrong. But drawing those lines at a time when we are engaged in, after all, it is a war. The authorization for the use of military force is still in force. Drawing lines between what is a permissible and not permissible use of force. You don't give trials to people right on the battlefield before you shoot them when they're coming at you. Is this different because so many innocent civilians are killed? A whole panoply of questions. I'm not sure.
Yeah, it's just kind of a frustration, I guess, that we hear the term rule of law a lot.
We have to keep it to one question, okay? Kathy.
Thank you, Larry, for a magnificent lecture on what you've acknowledged as one of my favorite topics. And thank you for the very kind words from the Dean and from yourself. I just thought it might be helpful to the audience to discuss something about the apparent shift from left to right, from liberal to conservative in the advocacy of a limit on unconstitutional conditions. And I'm oversimplifying here, but as you mentioned, it was really an invention of liberals like Brennan to say the state shouldn't be able to condition benefits to veterans on loyalty oaths, shouldn't be able to condition public broadcasting subsidies on not editorializing in a way that might be too liberal, on not conditioning legal aid funds, on the
Right, the
withholding
Velasquez
of,
case.
Velasquez case
was
referred to
mentioned
by the
earlier,
earlier
right.
questioner, not conditioning legal aid funding on the decision to forego advocacy of challenges to the laws governing the indigent clients that you represent. So you might say that over time, unconstitutional conditions originated with so-called liberal justices trying to defend so-called disadvantaged people who might be overwhelmed by the all too powerful state. So what explains now the idea that Justice Kagan, a so-called liberal justice, would make a mistake about unconstitutional conditions while Chief Justice Roberts, joined sometimes by other conservatives like Justice Alito, and I'll just cite, for example, the Christian Legal Society versus Martinez case, where the so-called liberal justices plus Kennedy said there's no unconstitutional condition in telling the Christian Legal Society that it can't discriminate against gay people if it wants to get funding and recognition from the University of California at Hastings Law School. It was the liberals who said, oh, it's just a subsidy. Subsidies, the traditional conservative position is he who pays the piper calls the tune, he who takes the king's shilling is the king's man, and so forth.
Right.
Now we hear liberals taking the other position. So could you comment on the apparent shift from left to right in the perception that there's a problem with unconstitutional conditions?
I think it is a problem that is an equal opportunity problem. There's no particular tilt, left or right, to the problem. That is, whatever you think is the sort of constitutionally appropriate distribution of rights, the idea that an all-powerful government could redistribute things with carrots, even without using sticks, is going to be disturbing to you, regardless of whether the right you're interested in is a conservative right, like the right of private property, or a liberal right, like the right of religious dissent. I think in general that the liberal-conservative dichotomy is extremely unilluminating. This is just one example of how unilluminating. But there are some areas where you can imagine that there is, for a period of history, sort of a difference in valence. I mean, it is typically people that we think of as conservatives who are really concerned primarily about states' rights. And it's people that we think of as liberal or progressive who want a powerful federal government who can protect liberty in an affirmative way. But Brennan joined O'Connor in dissenting in South Dakota v. Dole, where the government said that if a state does not raise its drinking age to 21, it will lose just a little bit of its federal highway funds, 5%. Rehnquist, for the majority, said, oh, 5%, that's not enough to really hurt a guy, and therefore this is okay. Brennan and O'Connor said, no, once you start nibbling at the edges, you've got a problem. O'Connor was primarily motivated by her belief that an overpowerful federal government would undermine the autonomy of states as laboratories. Brennan was motivated by the belief that what's sauce for the goose is sauce for the gander, and if we can get this principle that the government shouldn't be able to leverage its massive resources well established, it will come back to benefit rights that I care about. Most constitutional tools are tools that can be deployed in support of ideologies of all kinds, and one of the themes that the book that I'm working on explores is how much we ought to abandon the effort to pigeonhole everybody. They're not pigeons. They're people with rather complicated and multivalent views. And the sooner we try to avoid stereotyping them, the better. Now, Kathleen has this wonderful way, both in her majestic casebook and in her writing and in her teaching, of crystallizing the ways in which the kaleidoscope turns and showing how ironic it is that X is on this side one time and Y is on this side the other time. My tendency, generally speaking, is to say that it's not so much the irony that X and Y flip positions, it's how we allowed ourselves to think of those as opposite positions to begin with, when that was kind of a simplification. I don't know if that helps, but...
Yeah, one last, couple more questions. Yeah.
So it sounds like, and please correct me if I'm mistaken, that a key factor you've identified, a key problematic factor, is the government forcing you to declare a belief one way or the other. So my question is, do you feel that there's a significant difference, and does precedent support that there's a significant difference between cases that involve some kind of public declaration and cases that are either just about action or about private behavior? So for example, would it be better if the government just said, you can't get money if you advocate prostitution, rather than forcing you to make a declaration? Or a government subsidy for something private, like putting solar panels on your house? So do you think that those cases are fundamentally different from the problematic ones you've identified?
Well, there are two axes that you're talking about, I guess, slightly oversimplifying. One of them is the speech conduct axis. That is, solar panels. I suppose I could put solar panels up as a way of expressing my views about climate change, but it's not an intrinsically communicative act. And for the government to subsidize solar panels more than it subsidizes fracking or some other way of getting energy is, although it has an impact on people's beliefs, everything has an impact on people's beliefs, but it's neither a compulsion that you express a view one way or the other, nor a prohibition on an expression of view. So the solar panel example is a nice contrast with anything that would have to do with public or private expression. But when it comes to expression, and this is the other axis in what you've identified, I don't think it really does matter whether the government is forcing you formally to state a view or preventing you from expressing a view privately. If the government said, if we get any evidence that you are talking to other people about your belief that prostitution is a perfectly legitimate way for people without money to get money from the one resource they have, which is their bodies, and if we know that you're saying that, we will cut you off from taking part in our programs. It seems to me that raises exactly the same issue as is raised by requiring you to make a pledge. It is true that to some extent, decisions like Barnett and Woolley express an added degree of sensitivity about the problem of making someone sign on the dotted line, making someone affirmatively pledge. It's a kind of action-inaction distinction, which was also important in the way a number of justices looked at Obamacare. That is, it's okay to tell people who are engaged in commerce how to behave, but actually forcing them to engage in commerce is a step too far. Now, a lot of people think that the action-inaction distinction is analytically confused, that it may correspond to some intuition, but sometimes an intuition is only an intuition. I think in the context that you're talking about, the distinction between forbidding someone to say something and actually making them serve as a mouthpiece does have some intuitive significance. One intuitive significance is that when you prevent someone from speaking, you are not sort of co-opting them as a tool. You're not using them as a means. There's something peculiarly offensive, not so much on the free speech axis, but on the personal integrity axis. If someone sort of makes you into their vehicle of expression, if they make you walk around with a slogan about the administration, sort of, in effect, commandeering your body as well as your soul.
I think I'm going to we've gone on way beyond where we should because this has been so fascinating. I want to say before we came up, I asked Professor Tribe what the thesis was of his book, which in retrospect, and anybody who's listened to this lecture understands was a very silly question. He talked about...
Was it? I didn't think it was silly.
I thought it was silly because he said that people analyze constitutional law on either in the academy sometimes at a stratospheric level that really doesn't understand what is going on in terms of the cases, or with journalists who essentially follow the right-left split as it divides. And the thesis of his book, as you could see from this lecture, was to understand the true ideologies in terms of doctrine and theory of the justices, right and left, as they work their way through the court. Your thesis being, as I understand it, that what you read in the papers really doesn't capture what's going on in terms of the true balance of decisions of the justices.
Right. But when I'm asked to go on a book tour, would you agree to do it instead of me?
But I was going to say, this is the first time, having served as dean for 13 years, at the end of the Roberts Lecture, I feel like hawking a book. And I encourage everybody, June 1st?
June 3rd, but it's already on Amazon, so be my guest.
I encourage you all, as I'm sure you will want to after this lecture, to purchase the book. This has been magnificent. And
Thank you.
Thank you.
Thanks a lot.
Thank you so much. I know many of you had more questions, so I invite you all downstairs into the Great Hall for food and refreshments and an opportunity to talk with Professor Tribe in more detail. Thank you all.